Now we proceed to our second keynote speech. Please give a big hand to welcome President Xi to host the speech.
So, ladies and gentlemen, I'm very delighted to host the second keynote speech of this conference for you. The topic of the keynote speech is the development of constitutional review and the human rights protection by the Constitutional Court of Lithuania, by President of the Constitutional Court of Lithuania, Honorable Dr. Professor Danius Zalimas. As I mentioned in the opening remark this morning, President Zalimas canceled this visit accidentally. Upon his approval, we invited Dr. Chen Yujie to deliver President Zalimas' speech in his state. I would like to thank Dr. Chen for her kind help in such a short notice. Dr. Chen Yujie is a postdoctoral scholar at the Academia Sinica and an affiliated scholar at the U.S. Asia Law Institute of NYU School of Law. She received her JSD and LLM degrees from NYU School of Law. She also holds an LLM and LLB from National Zhengzhi University in Taiwan. Yujie has had extensive experience as a research scholar at the U.S. Asia Law Institute. Prior to that, she served as a researcher and advocate for the non-governmental organization Human Rights in China. She earlier practiced in the Taipei-based international law firm D&D. Her research interests focus on human rights and the rule of law in China, Taiwan, and cross-strait relations. So now let's welcome Dr. Chen Yujie.
Ladies and gentlemen, good afternoon. My name is Yujie. It is my honor to deliver President Zalimas' speech today, and I'll try to do this in the following 35 minutes. And my colleague there will help me with the PowerPoint. Today's topic is the development of constitutional review and human rights protection by the Constitutional Court of Lithuania. Danius Zalimas, President of the Constitutional Court of the Republic of Lithuania. It is an honor for me to be here today and together with you to commemorate the 70th anniversary of the Constitution and the Constitutional Court of Taiwan. 70 years are marked by great achievements in building and developing the democratic constitutional order in Taiwan, which is founded on the rule of law and the respect for human rights. Sometimes this has been done in particularly difficult conditions faced by Taiwan. This has been possible to achieve also due to the activities of the Constitutional Court. Although we are separated by oceans and thousands of miles, we do not feel this distance looking at the jurisprudence of the Constitutional Court of Taiwan, which can serve for the constitutional courts around the world as one of the most striking examples of the strict following of the rule of law and human rights protection. Let me recall that the relations between our constitutional courts were established more than 10 years ago. Last year, the delegation of the Constitutional Court Judicial Yuan took part in the 4th Congress of the World Conference on Constitutional Justice in Vilnius. We're proud of having you as a partner of international judicial cooperation and dialogue. In my report, I will deal with 3 issues that can reveal how the mission of the Constitutional Court is understood and pursued in Lithuania. First, the evolution of powers of the Constitutional Court in pursuing constitutional review within the framework of the Constitution. Second, the perception of the Constitution as a jurisprudential constitution. Third, the main features of the human rights doctrine. First, the evolution of the powers of the Constitutional Court. The powers of the constitutional courts established in the text of national constitutions may vary from country to country. The common power is the control over the constitutionality of legal acts. In this way, constitutional courts carry out their duty to remove unconstitutional provisions from the respective legal systems. Both the Lithuanian and the Taiwanese constitutions provide for this power of the respective constitutional courts, although in a different manner and scope. Meanwhile, other powers granted to the constitutional courts can be different, delivering an official interpretation of constitutional provisions, various kinds of involvement in the impeachment procedures, settling disputes between state institutions, determining the legality of elections, ruling on the constitutionality of political parties, etc. However, it is hardly possible to enumerate all the powers or all aspects thereof of the constitutional court in the Constitution, which may be necessary for the performance of its mission to ensure the supremacy of the Constitution and the rule of law. The provisions of the Constitution of the Republic of Lithuania that establish the powers of the Constitutional Court are also formulated rather laconically. Thus, like other provisions of the Constitution, they require interpretation by the Constitutional Court as the sole official interpreter of the Constitution. Namely, here there is a room for the implied powers that can be derived from the constitutional mission of the Constitutional Court, interpreted together with the expressly provided powers. These implied powers are found in the Constitution in response to the non-traditional or unusual attempts of unconstitutional legislation, or sometimes even seeking to prevent unconstitutional actions. Without a doubt, here a lot depends on the determination of the Constitutional Court to cope with the newly emergent challenges and to implement its mission in the most efficient way. In disclosing its implied powers in its jurisprudence, the Constitutional Court is led by two main principal clauses. First, no compromise can be made at the expense of the Constitution and the rule of law. Second, under the Constitution, the Constitutional Court is the institution of constitutional justice, which administers the constitutional justice by ensuring the supremacy of the Constitution and constitutional legitimacy in the legal system. Therefore, the rulings of the Constitutional Court should address not only the abstract issue of constitutionality of the impugned legal act. When necessary, they should also be adjusted to the concrete circumstances of the case and constitutional dispute in order to make the ruling effective, rather than only declaratory. Let me illustrate the evolution of the implied powers of the Constitutional Court by the following examples that can be regarded as the most important for the protection of human rights. First, from the jurisprudence of the Constitutional Court, we can see the well-established principle that no legal act may have immunity from constitutional review. This means that there should be no gaps in the system of constitutional review. The principle that no legal act may have immunity from constitutional review explains why the Constitutional Court can decide, for instance, on the constitutionality of constitutional amendments adopted either by the Parliament or by referendum. Although there is no express constitutional provision on the judicial review of constitutional amendments. However, it is clear that in the absence of the judicial review, the procedural and material limitations established by the Constitution for constitutional amendments would become meaningless. Therefore, it would be reasonable to state that the judicial constitutional review of constitutional amendments should be regarded as an imminent function of constitutional justice, that is, of any constitutional court, whether or not this function is expressly provided in the text of the Constitution. The same logic applies to the acts adopted by referendum. The Constitutional Court stated about its powers to review constitutionality of laws or other acts passed by the referendum, although this kind of legal acts are not mentioned in the text of the Constitution as an object of the Constitution, of the constitutional review. Secondly, the evolution of the implied powers of the Constitutional Court can also take place on the basis of the prohibition to overrule a final act of the Constitutional Court. This principle arises from the binding nature of a final act of the Constitutional Court, as well as from the finality and non-appealability of a final act of a Constitutional Court, as expressly established by the text of the Constitution. The possibility for the Constitutional Court to declare null and void all the consequences of a legal act that overrules the legal power of a final act of the Constitutional Court discourages the deliberate adoption of knowingly anti-constitutional legislation. Thirdly, the implied powers of the Constitutional Court to declare the impugned legislation null and void can also be applied in cases of the gravest breaches of the fundamental constitutional values or principles. Second, concept and the principles of the development of the jurisprudential constitution. The development of constitutional review in Lithuania can be associated not only with the evolution of the powers of the Constitutional Court, it is inseparable from the concept of the jurisprudential constitution. Emerged approximately after the first decade of the functioning of the Constitutional Court, when the existence of such a constitution could be confirmed by both qualitative and quantitative parameters of the jurisprudential part of the Constitution. The jurisprudential constitution is understood as the official interpretation of the text of the Constitution and its meaning in the jurisprudence of the Constitutional Court. That is, it is referred in the jurisprudence of the Constitutional Court as the official constitutional doctrine. It is developed by the Constitutional Court by exercising its inherent function to interpret officially the Constitution in adjudication of the constitutional dispute. The Constitution, perceived as the jurisprudential constitution, is vital for three purposes. First, only this concept can ensure the real supremacy of the Constitution, which implies the uniform and binding understanding and implementation of the constitutional provisions. Secondly, it ensures the stability of the constitutional order, in particular, the effective safeguarding of the constitutional foundations of the state and its people, the independence of the state, democracy, the respect for human rights, the Western geopolitical orientation. Thirdly, it ensures the progressive development of the state and society, as it is the living constitution, which is capable to adapt the text of the Constitution to the changes in the development of society and international life. That is, to avoid unnecessary changes and turbulences in the constitutional order. From the jurisprudence of the Constitutional Court of Lithuania, we can see that the development of the jurisprudential constitution or the official constitutional doctrine, the jurisprudence of the Constitutional Court, is based on the following main principles. First, gradual development. Second, consistency. Third, the inadmissibility of interpretation of the Constitution based on lower-ranking legal acts. Fourth, the harmonization with international and European Union law. Fifth, the application of different methods of the interpretation of the Constitution. One significant case I can mention as an example of the application of different methods of the interpretation of the Constitution. It is the case regarding constitutionality of the death penalty, which was considered in 1998. In terms of the purely formal point of view, the Constitutional Court could decide that the Constitution was silent about and therefore did not prohibit the death penalty, as there is no mention of it in the text of the Constitution at all. Moreover, at that time, Lithuania was not yet a party to Protocol 6 to the European Convention on Human Rights concerning the abolition of the death penalty. However, the Constitutional Court adopted an approach based on the respect for innate human rights and openness to trends of humanization of international law. The Constitutional Court noted from the outset that in deciding on the constitutionality of death penalty, regard should be paid to the fact that the Constitution is an integral act, consolidating the protection of human life in a number of its provisions. According to the Constitutional Court, it was also important to assess the relevant trends in the attitude of the international community regarding the death penalty, the international obligations of the state of Lithuania, and the experience of the historical development of the state of Lithuania in establishing this punishment in criminal laws. Thus, it was held that the lawfulness of the death penalty had to be investigated, taking into account various aspects. Applying the historical method, the Constitutional Court overviewed the legal regulation concerning the death penalty starting from the 16th century statutes of the Grand Duchy of Lithuania up to the present times, and drew the conclusion that even early legal regulation provided restrictions limiting the application of this punishment. And at the beginning of the 20th century, following the creation of the modern Lithuanian state, the death penalty was regarded as immiscible in the absence of extreme circumstances. In using the systemic method, the Constitutional Court pays special attention to the constitutional provisions consolidating the recognition of the innate nature of human rights, the right to life, and the prohibition of torture and cruel, inhumane, or degrading treatment. The Constitutional Court noted that the death penalty seizes human life, and there's no possibility of rectifying a mistake if a person who does not deserve it is sentenced to death. Besides, it was held that the death penalty derives the convict of human dignity, as the state in this case treats the person as a mere object that needs to be eliminated from the human community. The systemic method also created the preconditions for the Constitutional Court to take account of the development of international standards with regards to human rights protection and, in particular, of the emergence of the European standards concerning the inadmissibility of the death penalty. In this respect, the Constitutional Court invoked the striving for an open, just, and harmonious civil society and a state under the rule of law, as established in the preamble to the Constitution, and drew on the constitutional provisions consolidating the obligation of Lithuania to follow international legal norms and principles. After considering the relevant international treaties and multiple soft law documents adopted by the United Nations General Assembly, the Council of Europe, and European Parliament, the Constitutional Court came to the conclusion that the abolition of the death penalty was increasingly regarded in Europe as a universally recognized norm. Based on the comparative method, the Constitutional Court also pointed to the evident trend in criminal law of European states towards the humanization of criminal punishments. Thus, the application of the whole range of different methods of the interpretation of the Constitution enable the Constitutional Court to provide the arguments supporting the conclusion on the unconstitutionality of the penalty, which, in the words of the Council of Europe, serves no purpose in a civilized society governed by the rule of law and respect for human rights. Third, the main features of human rights doctrine. The constitutional doctrine of human rights can serve as one of the excellent examples of how the principles of the development of the implied powers of the Constitutional Court and the jurisprudential constitution are applied. It is also the demonstration how the substantial concept of the rule of law influenced the constitutional concept of human rights. In 1995, the Constitutional Court noted that literal interpretation of human rights alone is not acceptable for the nature of the protection of human rights. More than one occasion, the Constitutional Court has emphasized that the constitutional order is based on the priority of the rights and freedoms of a human being and a person as the greatest value. These provisions are the points of departure in the formulation of the further doctrine of human rights. In interpreting the constitutional provisions on human rights, the Constitutional Court has to take into account the overall constitutional regulation, including the relevant explicit and implicit provisions and principles, as well as the constitutional values. In other words, the Constitutional Court is guided not only by the letter of the Constitution, but also by its spirit. Also, it uses all the available powers to protect human rights as the greatest constitutional value. Here, it is not possible to make the detailed overview of the whole constitutional human rights doctrine. However, we can find the following characteristic features of this doctrine. First, the recognition of irrevocability of innate human rights. Second, vertical and horizontal protection of human rights. Third, negative and positive obligations of the state in the field of human rights. Fourth, the criteria for the restriction of certain human rights. Fifth, international and the EU law as the constitutional minimum standards for human rights protection. Irrevocability of innate human rights. In 1998, the Constitutional Court attempted to define innate human rights in the following manner. The innate nature of human rights means that they are inseparable from an individual and are linked with neither a territory nor a nation. An individual possesses his or her innate rights regardless of whether they are entrenched in the legal acts of the state or not. Every individual has these rights, and this means that the best and worst people have them. Innate human rights are an individual's innate opportunities that ensure his or her human dignity in the spheres of social life. They constitute that minimum, that starting point from which all other rights are developed and supplemented, and which constitute the values unquestionably recognized by the international community. In 2012 and 2014, the Constitutional Court had the opportunity to interpret the fundamentals of the Constitution and held that the innate nature of human rights and freedoms, as well as democracy and independence of the state, are the supreme constitutional values that cannot be denied in any circumstances. It is only logical that due to this reason, the Constitutional Court held that it is not permitted to adopt any such constitutional amendments that would destroy the innate nature of human rights and freedoms. As well, the Constitutional Court stated about its implied powers to declare null and void any legislation that would grossly violate innate human rights. In this context, It is worth to note that the similar approach has been taken by the Taiwanese Constitutional Court. As pronounced by the court, constitutional amendments shall be deemed improper insofar as they deny the most critical and fundamental tenets of the Constitution as a whole. The fundamental rights of the people and their protection under the Constitution are one of some of the most critical and fundamental tenets of the Constitution as a whole. Vertical and horizontal protection of human rights. According to the Constitution, the state is constitutionally obliged to ensure the protection of human rights and freedoms from any unlawful attempt or limitation by legal, material, or organizational means, and to establish sufficient means for the defense and protection of human rights and freedoms. Then it is logical that under the Constitution, the state has the obligation to ensure that human rights are not violated, not only by state institutions or officials themselves, but also by other persons. That is, obligations to ensure not only vertical, but also horizontal protection of human rights. Negative and positive obligations of the state in the field of human rights. One of the preconditions for ensuring human dignity as constitutional value is the duty of the legislator to guarantee the proper protection of human rights and freedoms. Therefore, the state may have not only negative, but also positive obligations in the field of human rights. The Constitutional Court has formulated in its acts, for example, an extensive official constitutional doctrine of social security, inter alia, social assistance, and has identified the constitutional imperatives that should be heeded in the respective legal regulation. According to the Constitutional Court, the state has the positive obligation to create such a system of social maintenance that would enable one to maintain the living conditions in line with the dignity of a person, and in case of need, it would render the necessary social assistance for the person. The criteria for the restriction of certain human rights. In its ruling of December 29, 2004, the Constitutional Court held that the recognition of the innate nature of human rights and freedoms does not deny the fact that the implementation of human rights and freedoms may be subject to limitation. According to the Constitution, it is allowed to limit the implementation of human rights and freedoms if the following conditions are complied with. First, the limitations are established by means of law, statutory law. Second, the limitations are necessary in a democratic society in order to protect the rights and freedoms of other persons and the values consolidated in the Constitution, as well as constitutionally important objectives. Third, the limitations do not deny the nature or essence of the rights or freedoms. Fourth, the constitutional principle of proportionality is observed. These criteria are essentially identical to those provided by the European Convention on Human Rights and the European Court of Human Rights for the limitation of certain conventional rights. Like under the Convention, certain rights, such as the right to life and the prohibition of torture or slavery, are absolute and cannot be restricted in any circumstances. Denying of these rights would amount to rejecting the innate nature of human rights and would essentially compromise the dignity of the person, treating the person as an object and not as a goal. A good example of the well-established practice of the Constitutional Court is the doctrine of restricting human rights, in particular the applicability of the principle of proportionality in the context of the economic crisis. The economic crisis, which was experienced in Lithuania in 2009 and 2010 resulted in the major challenge to the Constitutional Court of balancing in a fair manner competing constitutional values, social guarantees, individual social rights on the one hand, and the need to cope with a significant budget deficit, the public interest of physical stability on the other hand. In other words, Constitutional Court faced the problematic issue of how to reconcile the inevitable anti-crisis austerity measures and the requirements of the rule of law, since these measures usually affect the level of guaranteeing social and economic rights, and to a certain extent require derogations from such legal principles as legal certainty and equal rights. International and the EU law as the constitutional minimum standard for human rights protection. As mentioned, international and the EU law, as well as to some extent the jurisprudence of foreign constitutional courts, has to be also regarded as the sources for the interpretation of the Constitution. Otherwise, the state and society could find itself in self-isolation. That is, the situation that would not be compatible with the principles of an open civil society and the respect to international obligations, as well as ultimately with the requirements of the rule of law. That is why it is logical to perceive international and the EU law as the constitutional minimum standard for the human rights protection. If under the Constitution, the state is obliged to follow the generally recognized norms and principles in its international relations, then there's no constitutional ground to apply the less favorable standards for its own people. Therefore, as a consequence, once it is established that the law provides for the less favorable standard of human rights protection than that established by international or the EU law, that is the European Convention on Human Rights, it is the basis to declare this law unconstitutional. For example, on this basis, the Constitutional Court declared unconstitutional the provision that allowed to apply retroactively the part of the definition of genocide under National Criminal Code, which was broader than that established by the 1948 Genocide Convention. It included also the genocide of political and social groups. Conclusion. The overview of the development of the constitutional review and the protection of human rights by the Constitutional Court of the Republic of Lithuania demonstrates what principles should be followed in order to carry out successfully the mission assigned to any constitutional court. That is, to ensure the supremacy of the Constitution, including the human rights protection, and ultimately the rule of law. First of all, it is up to the Constitutional Court to find all the necessary means within the constitutional framework for the efficient pursuance of this mission. That is, to find in the Constitution the necessary implied powers that will allow protecting the constitutional order without compromises at the expense of the Constitution and the rule of law. In particular, the Constitutional Court can and must ensure that no legal act is immune from the constitutional review and that the prohibition of the overruling of the decision of the Constitutional Court is observed. For this purpose, when necessary, in interpreting the Constitution, the Constitutional Court can reveal its own implied powers that can be justified by the mission of the Constitutional Court, including the powers to assume the jurisdiction over the acts not expressly mentioned in the text of the Constitution, and the power to declare null and void all the consequences of anti-constitutional acts detrimental to the foundations of the constitutional order. Secondly, it is up to the Constitutional Court to develop the jurisprudential constitution i.e. the official constitutional doctrine, which ensures both the stability and dynamism of the constitutional order, as well as the independent functioning of the court. In this respect, the development of the jurisprudential constitution can be successful, provided that it is based on the principles of gradual and consistent development, the inadmissibility to interpret the Constitution on the basis of lower-ranking acts, the harmonization with international and the EU law, application of all available methods for the interpretation of the Constitution. Then the development of the jurisprudential constitution is capable of building the real constitution-centric nation legal system, where the Constitution is perceived as a supreme law without gaps, to which all other acts must comply. At the same time, under the system, the Constitution is open to the progressive development of international law, international and the EU law. It is also perceived as a living constitution, constituting not only of its letter, but also having its spirit. The principles of the evolution of the powers and the development of the jurisprudential constitution are also applied in the formation of the human rights doctrine by the Constitutional Court. Here, guided by the substantial concept of the rule of law, the Constitutional Court, first of all, can take all available means to protect innate human rights, in particular human dignity. Under any constitution, even in the absence of the express provisions, the Constitutional Court can find irrevocable values, including human dignity, that cannot be denied by no one and by any means. Secondly, these values are also protected by international law. Here, the Constitutional Court can and must consider the respective international rules as a minimum constitutional standard. To sum it up, all of these principles reflect the language common to the constitutional courts around the world. This is the language of the rule of law as a universal concept that unites us in performing our mission. This language also helps us to maintain the same direction of the river under the changing challenges to the rule of law. The development of the constitutional review, including the protection of human rights, leads us to the continuous disclosure of new elements of the constitutional reality and the further development of the already existing ones, as well as the harmony between the spirit and the letter of the Constitution. It is gradual, consistent, ongoing, and never-ceasing process. The peaceful and progressive development of our societies should also follow the same path. Let me express my sincere gratitude for your kind invitation to be a speaker in this conference. Thank you very much for your attention.
We thank Honorable President Dr. Daniel Zillema for his insight and thank Dr. Chen Yujie for delivering the speech.